It is a very good initiation. Good evening, everybody. This is a very important occasion that our university library is celebrating the centenary year, and in recognizing that we are having a series of lectures, webinars to enlighten you on various aspects of academic discipline. Therefore, today's the session is dedicated to intellectual property rights, protecting academic intellectual property, prospects and challenges for Sri Lankan universities. This is a timely topic that warrants rigorous academic attention in this country, because everybody is speaking about, everybody is talking about academic intellectual property. I must, I'm very grateful to the Madam Librarian and also her staff for inviting me, and I consider this is an honor to speak to the distinguished academics and other staff members of the University of Colombo. It is a unique occasion in my life after assuming the deanship. This is the second occasion that I'm speaking at a public forum, and this is something very unique to me personally, but I will try to make you enlightened on the topic that I have been assigned to speak about in today's session. So my topic is protecting academic intellectual property, prospects and challenges for Sri Lankan universities. At the very outset, I would ask you, how many universities are in Sri Lanka right now? So you might come up with the different numbers. Of course, I would say the universities, all universities, 16 universities and 6 higher education institutions are discussing this topic. Therefore, I wanted to enlighten you, my university, our university, on this very special, very specific aspect in order to make your life better and also make your life rewarded for what you are doing. You all are academics and you all are researchers. You all are doing very important researchers in this country, in the entire world. So I think it is timely for you to learn, you to be aware of what academic intellectual property and what are the benefits and challenges for our university academia in this country. So my agenda, I have just put down a few points for our discussion, and I will not walk through each and every aspect, but I will try to make it as simple as possible so that everybody will be benefited. So I will start with the academic concept of academic intellectual property, very important concept, and then protection, management and commercialization, which is also very important from the global perspectives. And then what IP tools that you have in your dispose. And then how to use the IP system to protect and promote your academic research. Then I will move on to obtaining patents in Sri Lanka and abroad, prospects, and also I will enlighten you copyright. If you have questions, I would like to entertain questions, because in recent time, even our library would have had many queries and would have many queries in the months to come because of the new normal and also maybe copyright issues. So we'll discuss also copyright a bit, and then prospects of technology transfer and commercialization. That is what is expected from us to bring to the society, and then challenges encountered by academic community in protecting your academic research by using the IP system of the country. And then I will also give you a bit of flavor, bit of understanding about the University of Colombo IP policy, which was adopted in December 2017, that you should know of this, because all academic researchers in the university should know this. I will try to shed some light on this, and then I will offer my concluding remarks, and then we will initiate discussion. Kindly tell me when I cross your time limit if I do. So I will walk through the basic idea. I must, at the very outset, I must tell you, all, as I mentioned to you earlier, all 16 universities in this country and 6 higher education institutions are more deliberating on this issue, this protection of academic intellectual property. Far too long, the universities have been perceived as monopolies of knowledge, and they are sitting on ivory towers. We are sitting on ivory towers, not knowing the reality in the society. You think that we think only theoretically, and we would not have ideas would have little use in the society. And then the idea came up that universities are gold mines of knowledge, and it produces original research, create useful technologies, and has enormous potential for university-based economic development. And many countries have been very keen on this for the long-term sustained economic development through university-based technology transfer. And Sri Lankan universities system is no exception to this reality. Academic, therefore, the university IP is something that you all, being university staff, should know about. Even my dear library staff members should know about intellectual property. The thoughts that I give in this, I offer in this session must be absorbed by everybody in the university system, because it is the future, and everybody is expected to know these things. And there was a concept in the established concept in the university academia, is that publish or perish, because because if you do not publish, you will not get promotions, you will not be recognized, you will not be known to the others. Therefore, intellectual property capital of university academia can create valuable commercial innovations and creations. So, standing on the frontier of knowledge, university researchers would start successful high-tech companies such as gene tech, Google, and create valuable IP such as hepatitis B vaccine and pain medication, Lyrica, and also you might have heard about Oxford AstraZeneca, and many universities in the world coming up with a lot of solution to fix this problem of COVID-19. So most of the things are coming as the university-based research, and they have been commercialized in many countries. Therefore, we have to be very mindful of this concept, publish or perish. But I would ask you to be careful about it. Before, if you publish without filing patent applications, then of course there also you will be perish. If you do not publish in the academia, you will be perish. But if you publish without filing patent application, then you will be also perish. So I just, it's ironical. I will further elaborate on this as we go on. Then,
can you disturb you with, because of the, can you enlarge your one presentation?
Right.
Yes.
Oh, sure. Right.
Okay.
Very well.
Sorry for that.
It's done. Okay. Thank you.
Yeah, thank you.
Right. So this is the concept of publish or perish. Right. So if you do not publish, you will be perish. And if you publish without filing patent applications or without protecting your IP, then again you will be perish. So I will touch that later. But of course, in the late 20th century, the concept emerged, the traditional wisdom has been shifted to academic research commercialization by many universities. And there was a concept, I think you all should know, there's a concept still in prevalent in the Nordic countries, Norway, Sweden, and European countries in some, the professor's privilege. And new concept is emerging as university ownership. Malaysia, Singapore, and many countries have developed a concept called university ownership. So professor's privilege necessarily means that professor, the researcher, retain blanket right, absolute rights to his or her invention, and nobody has the right over that. But that traditional professor's privilege is now being shaken, and all these countries are embracing a new norm called university ownership. That is where we stand today. So universities in the UK have adopted Lambert Toolkit that is providing a model contract and supporting guidelines in order to commercialize university inventions. That is something else. And now I will bring you to the story of protection and management. So that is the main focus of my discussion, my talk today, that is the concept of intellectual property. Simply put, intellectual property protects the creations, the finest creations of the human mind. Very importantly, even any thoughts coming through your mind should be protected if there is an original expression. Original means you have not copied from any other pre-existing source. So every idea emerging from your mind may be protected under different forms of intellectual property. In that sense, from a legal standpoint, intellectual property means right which result from intellectual activity in the industrial, scientific, literary, and artistic fields. In analyzing Sri Lanka, in Sri Lankan law, one has to understand our university system is governed by Universities Act number 16 of 1978 as amended. And there is a lot of discussion as to the amendment of the Universities Act these days. So University Act has no specific or direct provisions on the IP rights of the university academia. However, the Intellectual Property Act reads with intellectual property. When the Intellectual Property Act is read with the Universities Act, the universities having the IP as the employer of the works created and invented by the university academic. To put it more simply, if we are the employees of the university is the employer of us, and employer has the right of will own, I would say, accrue on the intellectual properties of the academics. Of course, our university does not, by the IP policy, does not claim copyright. Copyright will be left with us. But other inventions, for example, patents, maybe trademarks, industrial designs, trade secrets, etc., will be, if it is developed in the course of employment, that is called work for hire doctrine. If you have developed a new piece of software, then in the course of employment, it can be owned by the university and it is a university property. So this is the IP law. Read with the Universities Act. But Universities Act per se as such does not provide for the protection of ownership of intellectual property in Sri Lanka. That is where the new, whatever the amendment, will have to shed light on this. Then the next is the University Grant Commission Circular number 10 of 2016 and its implementation guidelines provide universities to commercialize, own and commercialize invention. So owning intellectual property will be by the application of IP Act. University can own property by virtue of the Universities Act. And then in order to commercialize, we have another circular. So I have mentioned three things now. Universities Act. Of course, university can own properties. No, intellectual property is a property. So academics intellectual property is a property. So intellectual property can be owned by the university because of the Intellectual Property Act has a provision. If the work was done in the course of employment, then university can own the rights of the rights over the intellectual property created by us, except for in the Colombo University, copyright is not owned in that way. And I will tell that for the reason later, the reason for this such decision. And now, then UGC circular is clear and it promotes university bringing innovative research output for the benefit of the people. And the university can bring our inventions and innovations to the industry for the benefit of the people, for the benefit of the taxpayers of this country. So, and for that, the management aspect is also important. When the university owns IP, university has to manage. So UBL or the Technology Transfer Office is there to manage intellectual property rights of the university. And rights will be divided by, will be distributed, or rights will be maintained, managed by the university by following the university IP policy. And that is this very important document, in University Intellectual Property Policy, adopted by in December by the Council of University Council of the University of Colombo, the Council of the University of Colombo. And now we are also adopting the research policy of the university. So all these three documents, all these two documents of the university, read with the UGC circular, IP Act, and also the Universities Act, would tell many things about the university academic intellectual property. And we move on. Then I will turn to the protection aspect of intellectual property. Intellectual property rights are the invisible gold in the 21st century. And it is the currency of the 21st century. It is not an exaggeration. Of course, it is the currency. The world is moving to innovation economy. Innovation economy, knowledge-based economy towards innovation economy. Innovation, without innovation, the country will be poor. It is not possible to raise the economic status of a country without creation of intellectual property. That is why the software industry of this country is now concentrating on ownership of intellectual property with regard to software industry. Then what are the IP rights that we can own? University academics will have many IP rights. For example, they will own patent rights, they will have industrial designs, they will have copyright, and we will not have geographical indication, but of course Sri Lanka has Ceylon tea, Ceylon cinnamon, Ruhuna curd, and many GIs made in. And then we also, universities have, I know many universities have registered their brand, trademark. And then we have also protection against unfair competition, integrated circuits and layout designs, trade secrets, and protection of new plant varieties. We don't have, but of course our colleagues in the Valigatta Center Institute will have many new plant varieties. I know, personally I know, they have developed many varieties of plant, and they need protection as well. So these are the main IP rights. Just to recap, we have patents, trademarks, copyright, then trade secrets are the most important intellectual property rights of the academic community. This is a patent certificate issued by the US Patent Office. I think we should measure our intellectual output by number of patents of the university on, and it is the reputation of the university. So inventions, innovation, and discoveries. You should also know, I think we have many researchers joining today. So it is the innovation, invention, and discovery. Discovery is not patentable because discovery is an act of detecting new facts about the nature. It is the first step before the invention. But invention is the very protectable subject matter. If you find something new, and it should be an invention in order to be protected. Innovation is a business term, doing something new. This is very much happening in many areas in Sri Lanka as well. Then I move on to the world has been changed by the inventions. You know, the telephone, electric bulb, printing machine, very important for library, and also the Wright brothers, plane, aircraft, which the first plane was invented by flying machine by Wright brothers. So these are the main inventions that have changed the fate of the world. And Sri Lankan patent certificate, I recently happened to see the original patent certificate as the director, UBL, and we received with a nice document here from the National Intellectual Property Office. And I'm proud of the inventors who filed and obtained, and they are patent owners now. So in order to obtain patents in Sri Lanka, this is, I must enlighten you, because our inventors in the university are filing or are disclosing their own invention without filing. That is where if you publish something without protecting, then even your publication will after some time will become novelty destroying piece of prior art. So I would say publish, but after protecting your IP. That is very important. I will tell how to protect your copyright in Sri Lanka before we turn to the end of this session, this particular webinar. So in Sri Lanka, first to file system is in place. So you have to file the patent rights, design rights, trademark, or so to say, all the IP rights. And Sri Lanka, patents are granted for an invention in Sri Lanka. What is an invention? Invention, somebody can think, I have an idea. Can I patent this idea? No. Idea as such cannot be patented, but an idea that can be a solution to a technical problem can be protected as patents. An idea as such, in law we call an idea per se, and as such cannot be protected, but a concrete form of an idea that can be a technical solution to a problem can be an invention, and that it can be related to a product or a process. So invention is a solution to a specific problem in the field of technology. Now we have many inventions. There is a great need in this country to find new solutions. COVID-19 pandemic has given a lot of new thoughts. While we were at home, we have come up with many inventions. So now you have to see, if you are developing a new device, new application to trace COVID contact or whatever, then you have to think, if it is a new novel application, new solution, we must think of protecting at least by using patent system, or if not, if it is software, at least by using the copyright system. And in the US, very famous case, Diamond versus Chakrabarti, court said that Supreme Court of the United States stated that anything under the sun that is made by man is eligible for patent protection. But that is an exaggeration, and we will not be able to protect everything under the sun in Sri Lanka. Technology in the layman's, in lay people or layman's perspective application of scientific knowledge for a practical purpose. But in technology, it is a technical, it is teaching for systematic action using controllable natural processes to achieve a results with clear cause and effect. This is a red dove case. This is a world famous definition adopted by many countries. In Sri Lanka, many inventions can be patented as per the section 62 of the Intellectual Property Act. However, there are certain things that cannot be patented. For example, plant and animals, mathematical algorithm, method of doing business, nuclear material or atomic energy. Inventions going against public morality cannot be patented in Sri Lanka. There are 3 conditions to protect patents: novelty, inventive step, and industrial applicability. You need to satisfy these 3 requirements. Novelty means my invention is new anywhere in the world. Inventive step means my invention is a significant forward step from the existing knowledge. It has a significant contribution over the prior art. And then industrial applicability means my invention can be used by any industry. Invention must be new and it should not be seen in the prior art. Prior art means the knowledge that exists at the time of the invention. It can be written publication, it can be use, or it can be any oral disclosure, right? Even the Ola leaf manuscript can also be written description as against any Ayurvedic invention. An inventive step is a significant contribution to the advancement of technology. And there are also additional considerations such as long felt need in the technology, unexpected result, industry demand, commercial success are the most important other factors in granting patents. Industrial application means it's very easy that it must be used in any kind of industry. Then the IP rights of the owners. Remember, intellectual property rights are territorial. What do you mean by territoriality? Territoriality is the concept that all IP rights are territorially protected. If you obtain patent rights, if you obtain copyright, it is protected only in the country where it is protected or registered. Therefore, all IP rights are territorial application. That is very important that you should remember. Obtaining patent rights in Sri Lanka would only guarantee protection in Sri Lanka. That is very important. And there are two main concepts in obtaining patent rights in abroad. That is, one is going through the National IP Office, National Intellectual Property Office of Sri Lanka, you know where it is. And then based on that application, within 1 year, you have to go to other countries as you wish. Sri Lanka is a signatory to Paris Convention, and then you can go to other countries within 12 months by using Paris 1 year grace period. And if you want to go to many countries to obtain patent rights, you can also use PCT route, Patent Cooperation Treaty route, that is centrally based on Sri Lankan application or based on other country application. Within 12 months, you have to inform that you want to obtain international patent rights in many countries by using WIPO route. Even you can use the WIPO itself by filing the application with WIPO, but you have to go to other countries, designate these countries. Then there are these are the two main routes, the approaches that you can obtain patent rights for your invention in other countries. Then as Mark Twain has stated that a country without a patent office, good patents laws are just like crabs and could not travel anywhere but sideways and backwards, which means if you don't have a good patent system, good patent office, that country will not progress. And this is the same what the great poet Kumaratunga Munidasa once stated, that a country, no country can rise in this competitive world without innovation. Without innovation, no country in the world can rise and win the world, win the global competition. So obtaining patent protection, two routes that I mentioned to you, Paris route and PCT route, centrally administered by the World Intellectual Property Organization. I should, my discussion, this talk will not be complete without paying due attention to the very important aspect of copyright. Copyright is an important aspect for all academic members in the university system, because whatever you write, whatever you publish will be copyrighted, and it is the library. Our library is also the repository or the caretaker of copyright in our university, and library has many copyright protected works. So what is copyright? Copyright, right to copy, is one of the most important type of IP rights. From a practical perspective, copyright is all around us, and it touches our lives on daily basis. For example, when you are reading a book, watching a film, or taking photographs, copyright comes into scene. Copyright relates to literary, artistic, and scientific creations such as books, music, paintings, sculptures, films, computer programs, databases, advertisements, maps, technical drawing, to name but a few. What is the subject matter? Works. All these are works. Works are protected by copyright. And you must know, I appeal everybody, when you are the author, you have many exclusive rights, many exclusive rights. You can publish, you can use it, you can print it, you can distribute it, you can make CDs, you can rent it, you can do many things. You can give a license to others to use it. So according to the UNESCO Copyright Convention, copyright is recognized by C, small letter C, enclose. C enclosed in a circle. C, you have seen the symbol. And every website, magazines, and DVD, you will see this, the C symbol. And you must know how to make your copyright notice. My all staff members in the university system, please make your copyright clear to the others. So you use C circle at the front, and then mention your surname. If I take Madam Kurupu's work, so copyright symbol, Kurupu, and year of publication 2021. Whenever you design a new web page to the institution, so you should mention all right reserved, and you must mention put this copyright symbol. C circle, the maybe library, University of Colombo, 2019, or sorry, 2021. So this is the prima facie, this is the copyright protection for your work, because in Sri Lanka there is no copyright registration system. The moment you write your book, the moment you finish your writing the song, writing the book, writing the chapter, writing the article, the very moment you are the owner of that work. You are the copyright owner of the work. Therefore, please place copyright notice on your work. That is the most important aspect in this copyright notice as per the UNESCO convention. And I have seen many scholars are using this, but please keep it. If you want to really register, please register your copyright. India has copyright registration system. US has not. It is not very expensive. You can register. This is the most important certification to claim your copyright if somebody violates. What is violation? Infringement. Copyright infringement means the use by an outsider or third party without the permission of the author, without the permission of the owner of the copyright. If any act of using somebody else's copyright for a commercial purpose or for a unauthorized purpose, then there is a violation. We call in law infringement. And there is another, our library is also very concerned about plagiarism. If you take somebody else's work, sentences, and you put as of yours, as if it is yours, that is what we call plagiarism. Plagiarism plagiarism is the taking even few words, few sentences will be plagiarism. But copyright violation, you have to, of course, show that you have taken substantial amount illegally and use it for unauthorized purposes. So if it is used with the permission of the owner, then you are not in violation of copyright law of the country. So it's very important that you have a caveat or the notice, copyright notice, and respect others' copyright. Please make sure no harm that you mentioned. This is taken from somebody, the other source, and you are very much academically rewarded for the citations. Please do so without violating copyright of the others. And then I turn to the next portion. I think my time is also approaching. Time is also now coming to an end. Prospect of technology transfer and commercialization. We have in our, when you have copyright, when you have IP rights in your hand, you have to protect, and then you have to manage. Managing IP rights and commercializing IP rights will be facilitated by the technology transfer office of the university, of the respective university. And for that we have university business linkage in the University of Colombo, and we also have a cell, technology cell, science cell. Likewise, there are some other arrangements also, but university central organization, university technology transfer office is there. And there is also possibility of private public partnership. It is the new norm, PPP. And then some universities such as Moratuwa University, and as far as I know, Jawardenapura University has initiated university startup, early stage business organizations to bring university research into the industry and make viable products out of the university invention. And then also in the implementation of the UGC circular, there is a need to establish this. UBL is a university grant commission's requirement, and it is under the circular 2016, number 10 of 2016, has necessitated our university to establish UBL, and UBL is functioning as a UGC norm, and to create institutional bridges between universities and industry, because university research should not accumulate dust on the shelves in the library or any other research lab without bringing such invention into products for the benefit of the people, for the benefit of the taxpayers of this country, and they who finance our research, they who finance our education. Therefore, I think we have a noble duty to bring our research results into the commercialization for the benefit of the people, the average taxpayer on the street. So that is that. Challenges encountered by the academic community, of course, most importantly, our academic community is not very fully appraised of the innovation, protection of innovation, protection of creations, and sometimes things will go unnoticed. That is the major or primary consideration that I want to flag here. You have to be enlightened, you have to be aware of the importance of the university research, protection of university research, and management. Management is also very important. not only to protect, you need to manage, and also if there is a viable product coming out of it, then you have to go for commercialization. And one other important issue is that how to share benefits with the researchers. That is, that has to be decided by the university IP policy. University IP policy. The modern norm is 1/3 for the researcher, 1/3 for the university, and 1/3 for the institution from where it is emanated. And also most university research, university technology transfer officers or protection mechanism is concentrated, or more into focus is the patent high tech. However, we have Sri Pali campus and art faculties, education faculty, and they are in good use in other countries. For example, you create a new dictionary, online dictionary. We only have hard copies, Malala Sekara, but what about if you develop new online dictionary, and that can be commercialized, that software developed, new dictionary can be commercialized. I have seen in other countries, even the university software programs, modules, and teaching tools, teaching materials being commercialized and owned by respective institutions and researchers, university writers, authors. And there are also issues with regard to the legal framework, because we don't have uniform university research policies in many universities, and some universities exempt copyright, some universities do not exempt copyright. For example, visual and performing arts has recognized even copyright should be owned by the university, but our university does not claim copyright. These are the main aspect that I wanted to. I have taken 45 minutes now, and in the final deliberation, I would also alert you that you need to become familiar with the IP rights, IP tools, and then try to make maximum benefit of the IP system for your benefits, for your protection. And then the university will be also, university reputation will be very high when the university any university owns IP, intellectual property rights, because it is something very much linked with the ranking, the innovation driven universities, research driven universities, and time is right for us to think afresh. And this culture, university IP culture should be promoted. Of course, I'm not a blind follower of IP culture, but we need to also balance interest of the students, interest of the academia, and also the wider interests of the society, where Sri Lanka is not a very developed country so far. So Sri Lanka needs to balance. For example, with regard to copyright, we might have to have certain level of flexibility as provided in the international IP treaties. So having said that, I think I have exceeded time. It's good to have also entertain questions and clear doubts if you entertain any. With that, I just finish this talk, and as my time has already allocated, time is now over. I'm happy to answer your questions if you have any question. If there are certain other points that if I am supposed to clarify, I'm happy to do that as questions arising. So questions emanating from your discussion, question arising from your text box messages.
I have a question.
Yes. Please,
I'm
Dr.
Kokila
Kokila.
from the Faculty of Law. And first of all, I thank the library staff and also Dr. Punchiheva for giving us this opportunity to expose to this very important area for any academic in the world today. So I have two clarifications, Dr. Punchiheva.
Please go ahead. Please go ahead.
First one is that I would like to know, because this is your area of expertise, I would like to know that where does Sri Lanka place within the world map in terms of intellectual property rights, especially in our context, the world of academia. My second clarification is that you mentioned that we have an IP policy for University of Colombo. Am I right?
Yes, yes, you are right. Absolutely
yes,
right.
Dr. Puncheva, could you please enlighten us on whether we have any simple guidelines for non-lawyers and for people who have general knowledge of intellectual property that can refer? Thank you so much.
Yeah, thank you so much. Sri Lanka, at the moment, Sri Lanka is developing intellectual property policies and developing intellectual property culture in the universities, because this is a new norm, I would say. My word is new, my praise for that is new norm emanating in the university system, because only 2016 Sri Lanka introduced this university IP related legislation. Not legislation, it's a UGC circular, and it requires universities to create IP policies and protect, promote and manage, promote, manage and commercialize IP rights. So that is there, but it is not perfect. It is far from perfect. We need for further development, and that is where Sri Lanka is still rather behind leading Asian countries like Malaysia, Singapore, and also East Asian countries, for example, South Korea, Japan, and other countries. With regard to the second question, on the second question, I would say there are the WIPO materials, World Intellectual Property, reader-friendly materials, the user guides, simplified version of how to protect libraries, IP rights of the libraries, how to protection of small intellectual property rights for business communities. Very simple. All these documents are available. If someone want, I can is in need of, I can provide the library. All these copies are with me, and also WIPO guides, simple guide for reader-friendly guides for new users. So that these things are available, and very important question. And you emphasize the importance of expanding the horizons of our knowledge. Very important. Without this very important area, maybe in another 10 to 20 years down the line, we will not be able to work, because this IP grip is coming very tight for us.
Thank you, sir. Another participant is asking whether Sri Lanka has these IP law, I mean, especially to protect the original idea, since US law is protecting original idea through IP. And do we have such laws to protect original idea?
Yes. Yes, an idea itself is not protected. Now, you may have an idea in your mind, which is not protected. Idea has to be transformed, translated into an expression. Expression means how you choose your words, how you express yourself, how you make your idea concrete and boil down to to a piece of paper. Idea itself is not protected, but idea has to be expressed, and the expression of your idea is protected by copyright. Concrete idea to resolve solve a problem in the field of technology is rewarded by the patent system, patent rights. Is that clear?
Yes, sir. Well understood. Thank you. And the second question from the chat is, how does
sorry, I am Pratibha speaking here. Yeah, I think she's asking whether USA some registration is there. Copyright.
Yes, copyright registration.
No, you don't have registration. That's why she's getting the clarification.
Sir, thank you, sir. And I'm delighted to see you also joining, sir. So in the US, there is a registration system for copyright. Now in Sri Lanka, there is no copyright registration system in the National Intellectual Property Office, whereas India has. Now, if someone wants to register your copyright, you can register in the US as well. And our neighboring country, India, has a copyright office, and you can register and obtain your certificate. That certificate is the prima facie evidence in any kind of proving or establishing your title to the work. That is very important. But of course, the Berne Convention does not require the registration as a formality, but registration gives you a rather stronger position, because then you don't have to establish that. When you have the registered right, then your position is very stronger in a case or lawsuit, or and also claiming royalties for your work. That is that. If I would say software industry is now turning to our copyright ownership. If you want ownership, I think you need to establish. But as the first step, please have the copyright notice, UNESCO copyright notice, C circle. If we say our rector, sir, C circle Mahanama Heva 2021. That is the copyright notice, and that copyright notice itself conveys a very powerful message that this is protected work.
Thank you, sir. Other question is, how does copyright work when an academic work or act with the publishers?
When you want to publish, I have published. I know I'm getting royalties also from the publisher. In Europe, it's very high amount. However, book is also very expensive there. When you publish, you will be required to sign your contract with the publisher. In most cases, publisher will ask you to transfer copyright, or you can give your license. You can license your right to the publisher for this 100,000 copies, and that is, you are giving a license, because as the owner of copyright, you have many rights. You can use it. You can distribute it. You can make CDs. You can publish in any other forms. So you have selected to publish with the University of Colombo Press. Then you have to assign maybe you have to license your copyright to the Colombo University Press. Then based on that, Colombo University Press will produce 1,000 copies for distribution. And so that is, you assign, you license. Remember, license means you permit this only publishing in print, but you are not giving your online publication rights. Likewise, you have to very clearly read the contract and demarcate your boundary. If you don't want the copyright, you can assign. Assign means, like, if you have a land, you are selling your land, then you have no more rights. But if you don't want to sell the land, but you want to give you rent it out for 2 years. Likewise, you get back the right again. You are only permitting somebody to reside there or to grow, cultivate. That is, there are different arrangements: copyright licensing, copyright assignment, and but you have to negotiate with the publisher whether you are going to license, giving an exclusive license to this publisher. If you are giving an exclusive license to the publisher, exclusive license to the publisher, then you will be given royalty payment. You will be given a payment as royalty, and also you will get for additional copies royalty of 10% of the sale. Generally, you get lump sum payment at the press stage when you give license, and then additional reprints you will get 10% or 12% depending on the demand, market demand for the book. There are licensing agreements. Of course, you have to. It is something. It's a legal arrangement, legal instrument that you need to negotiate with the publisher. Any other questions do you have?
Yeah, thank you, sir. Supplementary to that question, so I have another question. For example, it's based on a real incident where the organization or an association funds for a work. Let's say it's a project where somebody is hired and he or she does all the work, and after the project, that guy or the person wants to publish the same work in his copyright name, his or her copyright name. Does it work, or who holds the copyright?
Yeah, very pertinent, very appropriate question, because I have seen many MOUs. There are many arrangements with the different organizations. For example, collaborative projects. But in answering your question, I might have to see the contractual arrangement or the agreement that you have entered with the other collaborator. If it is funded by, for example, funded by the, say by UNO agency, and there is an agreement that you have entered with the organization that the ownership of the copyright emanating from your work will be on or shared by the author and the organization, or will be owned by the claimed by the author. It has to be decided by the contractual agreement. Are you clear?
Yeah, yes, sir. Thank you. And the next question is, what is the amount of protection given for patenting software applications or solutions in Sri Lanka? Do we have capable reviewers at NIPO?
Yes,
to handle
we do.
Such application?
We are blessed with our UCSC. They have enormous resources, and also Moratua. There are two institutions that can assess these things, and also patent examiners are of science background. They are capable of looking at whether there is an invention, and invention should have novelty, inventive step. Inventive step is the very difficult hurdle for the software invention, because it not only new is enough. You need to have a real significant contribution in resolving a problem in the technology. What software patenting is only allowed insofar as a novel solution in a non-obvious manner has been found by the inventor. It is therefore, with regard to software, copyright protection is the most forthcoming, very cheapest protection for them. But for the patenting is also possible, but you have to solve a technical problem in a new and non-obvious manner. Remember that you got to solve a technical solution in a new and non-obvious manner. Are you clear?
Yes, sir. So to rephrase, Sri Lanka has a patent office.
Yes. Even the banking system is having the machines, and they are based on the architecture, the digital architecture, and I know for sure there are some few patents on this. Patents. Protected technologies are used by banking system. ATM machines are used in this.
Yes, sir.
Clear?
Yes, sir. And
in the US and in the UK, this pandemic. They are referring to pandemic. This app trace and tracing app is also new solution. Tracing of COVID infected person is another solution, software implemented invention. Clear?
Yes, sir, got it. Another question regarding this ownership sharing. Formula of sharing the ownership of intellectual property.
It depends on the IP policy. IP policy.
Yeah, is it a standard formula? Asks.
It varies, but 1/3 inventor, 1/3 university, 1/3 the institution to which the inventor is attached to. Okay.
Yes, sir.
You can see that in the IP policy. I think you should see this IP policy. Yeah, the formula is here. Formula is very clear. Yes, as for our policy, section 10.3, inventor 50%, administrative body 30%, department 10%, University of Colombo 10%. This policy will be revised, of course, but as of now, this is the law. This is the policy of the university.
Thank you, sir. And I would like to ask another question. It might sound a little bit lay from a lay.
No problem. No problem.
Yeah. Does the copyright or any patent look into the environmental issues of any kind of innovation per se, or does it look into any social issues? Sometimes these days, apps and other things are popping out, which could be in long run or maybe indirectly detrimental to the system or sovereignty of the system or country, or personal issues privacy issues might pop out. So I'm wondering whether these things are looked into.
Green inventions are always welcome, and many countries have done so. Inventions will be protected, rewarded, and the issue that you mentioned, privacy and other things, will have to be looked at from different perspective. So there should be different set of laws to preserve privacy, and you should have technical measures and government regulations to protect privacy and other concerns. IP law, IP rights will only guarantee your right to the invention. So other things will have to be addressed from different perspectives, through different instruments.
So it's obvious other statutory laws are coming in.
Yes, yes, it should be. It should be the case.
Okay, sir. And I would like to know, since this idea actually emanated or stemmed from a Western perspective or Western context, usually Eastern cultures have different stance about copyright or ownership. So for example, I mean, generally speaking, we take things for granted and we don't give acknowledgement. So in that case, how does it addressed? How is it addressed in such situation? How is it balanced between cultural perceptions of copyright or intellectual property laws and the innovations?
Necessarily, intellectual property concept was emanated in the Western society. It is individualistic approach, whereas we have in our society the approach of community of property. And however, even in the time of ancient kings, there had been privileges. Today, we are in a commercialized society, market economy, and that it is not the time when Guru Lugomi or the Guru Lugomi wrote Amavatura, right? They wrote the Valmiki or the authors in the ancient time had the self-satisfaction. They were respected very much by the society. But today it is a materialistic society, very much money-driven, market-driven economy. Therefore, intellectual property rights are important, necessary, even in the Asian societies, because without which the inventive spirit of the people will not be emerge. Because if everybody can use with freely all the inventions, then who will invest in doing it. It's called crops in unfenced land. If you have a coconut garden without fences, anybody can snatch coconut from your garden, and you will invest no time, resources to grow coconut. So that is the same thing with IP. Are you clear?
Yes, sir, understood. And along that line, I am triggered to ask this question as well. In the West, intellectual property law or copyright or all other sister laws are reinforced by or strengthened by technology, so that nobody can reproduce somebody's idea. The crime or infringement is so minimal. However, in our country, most of us are, we have access to printing any kind of books, and we can submit it to get professorship in universities. And in such cases, they are likely to get away with fake materials printed in local presses. And in that case, technology is not supporting in catching whether it is on original publication or is it just copied off the internet or duplicated from somebody's thing, because we are not coming under that limelight of being caught.
Yes, this is I would respond to this very carefully, because maybe you write a book, and it might have been suppose that it might have been maybe reproduction of somebody else's ideas, but you can also look at the public impact. If somebody is enlightened by this reading your book, I think we should also respect the same way as it is a standard book from Oxford University. Sometimes if the materials are very expensive, perhaps we might have to think of local versions, and that is permitted. Even in the yes, we should not always discourage innovative ideas, perhaps with certain ideas being borrowed from somebody else's. Unless if it is copied word to word, if it is a plagiarized or copied word to word, because in law, something like in law, I have been always saying this, we have to rely on content analysis. For example, you cannot change the words of Satasium case. You cannot change the words in the Constitution. If you change it, then you will be also not arguing to the point. Then you will lose the case also. Likewise, if so there is a certain level of appreciation, margin of appreciation will be different from field to field. Is it clear?
Yes, sir. Definitely, we are for Creative Commons and fair use of information. At the same time, it could be crooked in a way.
Yes, there will be some people will be doing, but of course, many people, whatever the publication will be of benefit to the others. No, if that to that extent, we can appreciate it. Of course, we have to. If somebody alleges that my work has been copied, then we have to treat differently. Yes.
Yes, sir. Understood. Thank you so much, sir.
Yes, I think we have exceeded time as well. 10 minutes more. If there are questions, I'm glad to answer. If there is no question, we can take next step.
Yes, thanks very much, sir, again. And if participants have any other questions for Professor Puncheva, please do ask, or you can reach him if he likes to anytime. Thank you very much.